I'm having technical issues, but I think I'm all set.
Yeah, no, we see you. Welcome. And if you're ready, we're ready.
Okay. I'm sorry, I just have one thing. I get organized. I'll be right there. Sorry, apologize. Okay, good morning, Your Honors. My name is Alan Black. Good morning, Madam Chief Justice, and I represent Mr. Welch in this matter. Just want to say one thing before I start, please. I'm retired, and this is my last case, and I've appeared in front of this court for about 25 to 30 years. And I just want to thank you because this is my favorite. This is the one thing I'll miss is appearing before yours. And everybody over the years, starting with Justice Liakos, I think, have treated me with total respect. And I love being in front of this court. So saying all that, I will begin. So I spent a lot of time sorting out the facts for the motion to suppress because the facts are kind of complicated and convoluted. And that's the issue that I want to start with and probably spend a lot of time with. Mr. Welch was transported to Bay State Hospital after slitting his throat and cutting his wrists.
Mr. Black, let me ask you a question about that.
Yes.
The two cases that are cited, one's out of Vermont and one's out of New Jersey. One deals with the emergency department in Vermont, and the New Jersey case deals with a mental health facility with a longer period of stay.
Yes.
I know your argument about the ICU room. Could you please use those two cases to distinguish where there's a reasonable expectation of privacy in an ICU room, given the duration and his inability to control access to that room?
I'd be happy to. You're right. He was unable to control access to the room. He was unconscious most of the time until later on. But even the motion judge kept on referring to both rooms as private rooms, which I thought was fascinating. I mean, those were in his rulings and holdings at the end, at the end of the motion hearing. But he always referred to them as private rooms. Now, I understand most of the cases that say you don't have a reasonable expectation of privacy are ER cases. And the case that was decided by the judges against us was an ER. And I hope nobody here has ever been in ER, but in an ER, everybody, it's all open. People are coming in and out. Visitors are coming in and out. And I see that distinction. That distinction is exactly appropriate because there's really no privacy in an emergency room.
How much privacy do you have in an ICU room?
Well,
because by definition, it's the most serious cases are in the ICU, and medical intervention is constant in an ICU as far as people in and out.
Well, even in the Stott case, which I cited, the case that we cited, and I understand it was a mental health facility and he was going to be there a little bit longer, but he had a roommate in his room, and the court ruled that even if the defendant consents, which he did in that case, to medical personnel coming in and out, that doesn't waive one's reasonable expectation of privacy. I mean, he couldn't waive, they kept on asking, he couldn't waive anything. because he was unconscious for the first couple days. But in that case, in the Stott case, he did waive it to allow medical personnel to come in and out. And they said, well, that doesn't waive your reasonable expectation of privacy. Now, I understand the difference. He was going to be there a little bit longer. And they said, okay, well, that's his room, even though he was sharing it. So this was an interesting case because it's really in the middle of everything. And it's the first impression, I believe it's a case of first impression in the Commonwealth.
I think so too, Mr. Black. Let me ask you on another part of the motions, with the motion to suppress statements. I was a little unclear on this. As far as the facts go, he tells the police, I don't want to talk to you, I'll talk to you essentially when I get better the next day.
When I can't talk.
Yeah, I'm having trouble hearing you, Mr. Black. I'm sorry.
I'm sorry. He said that when I can talk,
okay,
I'll be able to do this, but not until this is serious.
Okay, and did the police abide by his request and wait for him afterwards?
No, and as a matter of fact, some of the most damning situations, they're all in writing, first of all, so he never could talk in that whole situation. And the police, and he told them, I can't talk to you till tomorrow when I can talk. And then the police came back 2 hours later and urged him to talk, and then urged him, even when he said no. During this interview, they urged him to keep on going and, quote, I think, finish this conversation. And
so the ambiguity, or the lack of ambiguity, is I don't want to talk to you now. I'll talk to you tomorrow, essentially, or when I'm better.
I don't want to talk to you until I can talk, speak. That's what he felt is when he could actually handle this. But he never spoke during this. All of this stuff was in writing.
No, I got that part of it. But no, I understand your argument, Mr. Black.
Okay.
I just need a clarification on the facts. Thank you.
Yeah, and there's a lot of, I just want to summarize this because I have 15 pages of notes trying to clarify the facts myself. And it's difficult, but I can say this with certainty, that when he was taken from his house in East Hampton and driven to Bay State, he was accompanied by a police officer. I think they tailed the ambulance. They drove right to the hospital. The first officer went right upstairs and sat. I think he sat outside the operating room. I can't imagine them letting him in, but I think my sister said something about him being in the room, but I actually don't think that that's correct. But I don't think it also matters because he was right at the door of the OR and he was unconscious anyway, the defendant, the entire time of surgery, obviously. And when he was transferred to his, quote, private ICU room, the cop went in with him initially. And there was always a police officer within feet, 1-2 feet of the defendant the whole time. So, I know when we get to the issue is, was he in custody? Which is one of the things that Judge Kinder relied on. He said that he was free to leave and nobody told him he wasn't. And the police officers kept on repeating, well, you can get up anytime you want. He was hooked up to machines. He was hooked up to, he was intubated.
But that's nothing the police did. Free to leave usually means they've got handcuffs on you, not that you're intubated or you're hooked up with an IV.
Well, free to leave means he's free to leave. And
but it also entails something that law enforcement has done as far as free to leave, correct?
I would think you're right, except in this particular case, when a patient is physically unable to leave, saying that you're free to leave is empty words. And he said it all the time. You're not under arrest. You can go anytime you want, the officer said. And he repeated that over and over and over again. And the defendant can't even talk, can't even do anything. So I think, to me, those were just empty words, meaning nothing. How was he free to leave? He wasn't free to leave.
But you need the, as Justice Graziano said, the state action involved with that. You can try and weave that argument into your voluntariness point, but the hospital, his health not allowing him to leave is not going to delineate what custodial means for the purposes of our constitutional analysis.
Well, let's analyze that for a minute from the perspective of the police. The police were there all the time. Was he really free to leave? I mean, look at it in this situation. If he said to the police, "Okay, I'm going to get out of here," really, do you think the police would let him? He was a prime suspect in a horrible murder.
Doesn't matter what the police would have done. As you know from Commonwealth versus Morse, it's objective from the perspective of the defendant as it relates to that, one of the non-exclusive Bryan factors. But it seems to me that if you want to argue where he was and where he could have gone and all of that, you could weave it into a voluntariness argument.
Which I did, as you know. That was a prime argument, and I used the testimony of the Commonwealth's own witness, Dr. Fife, and others. Nurse Duarte, I believe, also testified to the effect of him. He was on a fentanyl and oxycodone drip, and both of them testified that those particular drugs would absolutely result in confusion, not being able to understand correctly, not being able to process information. And I want to distinguish the quote delirium test that Nurse Duarte keeps on talking about that the defendant passed. Dr. Allison Fife, a Commonwealth witness, testified at the motion hearing that those combination of drugs could cause confusion, foggy brain, not being able to process information correctly. So I believe there's a very strong case for not being voluntary. The whole time he's hooked up, he can't talk. They just slit his throat was slit, his wrists were slit. And Dr. Fife even testified that in her opinion, this was a very serious suicide attempt. And the other interesting thing.
Mr. Black, let me turn you to two trial issues.
Okay.
The first is the prejudicial impact of the drunk driving conviction offense, where it strikes me that when we're dealing with a horrendous murder like this, the fact that he was charged with drunk driving doesn't seem like a big deal. Can you tell us why your client would have been prejudiced by the fact that the jury knows he drinks while he's driving?
Well, it does make him seem like, I understand the murder case is a lot more serious than an OUI, but it also makes him seem like a bad person. It does. He got charged about a week before this incident with drunk driving.
And the judge gave a limited instruction, correct?
Yes, he did. Yes, he did. A prior, a typical prior bad act instruction. Yes,
right.
He did. Trial counsel objected. I raised it on appeal.
Right. And then the last question
go ahead.
I'm sorry. Did you finish it?
Yeah, I finished it. Go ahead.
Okay. The last question I had, Mr. Black, on trial matters had to do with the authentication of the text messages.
Yes.
Here we have some context, and in particular, a vulgar nickname that's repeated. Does that give us enough comfort that these are truly his text messages?
Well, I cited Purdy, as you know, and You know, this case is a little different than Purdy. And that would be the argument that, of the other side, of course, that the phrase, and you know what the phrase is, that the phrase establishes enough of identification marker that it allows that in. But I think I argued that it wasn't enough. The fact that he used that vulgar nickname, or she used the vulgar nickname, I don't think that establishes the authenticity that Purdy requires. Is that all for you?
Those are all the questions I had for you, Mr. Black.
Thank you, Justice Gaziano. So can I go back to the motion to suppress? Oh, actually, I have 4 minutes left, so I want to say this. Under 33E, trial counsel did not, in sentencing, argue anything about the defendant's mental health history. Nothing. And I felt, I mean, Dr. Fife testified, so that's public information. And that's why I actually cited and quoted her, because she basically establishes part of the voluntariness issue. But if you look at, and I urge you to, I filed a Rule 8 motion to expand the record to look at, so he was examined probably 5 times. And all those times.
What's our case law on that, Mr. Black, given the mandatory nature of the sentence and the relative lack of opportunity for advocacy in these types of proceedings from the defendant? What do we said about what we expect defense counsel to do in a murder 1 conviction for sentencing?
Well, I mean, when I argue sentencing, I put in single thing about a defendant's mental health as possible, because I know you review 33E, and under 33E, you look at the entire record. And it was important in this case that even though Dr. Fife's testimony was helpful, it was not complete. And all the medical records, they were given to the court. So I had a question of whether I needed to do this or not, but they were never introduced as evidence in any hearing. So I filed a motion to expand the record to include the mental health reports. And again, there were about 4 or 5 of them. And you all have them. You haven't ruled on the motion, which I know you don't until after the argument, but I all have them. And I don't want to go into the details with it. I don't need to.
So your position is defense attorney should take the opportunity in a sentencing proceeding to complete the record for a 33E review?
For this court, sure. I always do. I mean, I always ask after a verdict comes in of guilty, I always ask the trial judge to give me a day or 2. And then in that day or 2, I go through everything I can, because if it's not on the record, you can't analyze 33E correctly. I mean, how can you? So these records will present a full picture of defendant's mental health history in detail, including his substance abuse issues and things of that sort, which came out with Dr. Fife. But I think it's important to see the full impact of the record. So just briefly, in 1 minute, I say that the judge relied heavily on that he had no reasonable expectation of privacy in his room, and then basically didn't decide anything else, like the voluntariness issue and things of that sort. Because once you don't have a reasonable expectation of privacy, there's no search, there's no seizure, there's nothing. And I argued, and we already talked about it, is that I think that was wrong. I think he did have a reasonable expectation of privacy, and I think his statements were not voluntary. And I personally will push back again about the statement that he was free to leave. I mean, I just can't imagine a situation that this defendant in this particular circumstance, and I understand it's subjective, was free to leave. Couldn't even talk. He didn't want to talk to the police until he could speak. So he started writing things, and the police kept him coming back, leaving, coming back, leaving, after he asserted this like 3 times.
Okay, do you have, does anybody have any further questions? Thank you so much, Attorney Black.
Thank you very much, Your Honor.
Okay, Attorney Von Flattern.
Good morning, Chief Justice Budd, members of the court. Cynthia Von Flattern, Assistant District Attorney for the Commonwealth. Sitting with me, though not in the courtroom, is Trial ADA Jeremy Bucci, our Chief Trial Counsel. With respect to issue number 1, the Commonwealth would submit that the defendant did not convey a subjective expectation of privacy in his room, and more particularly in the notes that were that he used to communicate with the medical staff and then with the police department. I find it a little bit difficult to conceptualize. It's not just about the privacy of the hospital room, but what were the fruits of what came out of that hospital room. And the police applied for a search warrant for the defendant's clothes that were in that room, for a search warrant for the defendant's blood and for his urine. They applied for a search warrant for the items that were found in the victim's apartment. So what we are left with are the communications. And as Justice Kinder found, the defendant did not convey a subjective expectation of privacy. He was seeking to communicate first with his medical staff, and there were only 4 statements. Justice Kinder had looked at a lot of statements. The testimony was for other statements that were conveyed to medical personnel and police, but what was introduced into evidence were just 4 statements written down to Nurse Wallace. With respect to the communications to the police, again, those were rather salient communications that were entered into evidence. The first were the defendant's communications to Trooper McMillan. Trooper McMillan was assigned to come to the hospital after the defendant had been brought there and had surgery. And he was one of the troopers that, when the defendant was unconscious, he was in the room with the defendant. And then the police moved to the hall. They were not in the defendant's room, but the defendant was, as conveyed in the note to Nurse Wallace, he was aware that they were there. So he asks a nurse, the defendant asks a nurse to get Trooper McMillan, and then he writes a note to Trooper McMillan about his landlord and about being behind on the rent and saying he had money to pay. So he actually sought out the trooper and wanted to convey to him. Most of the testimony.
Can you address the custody analysis? That seems a little tricky, the custody. I mean, he knows he knows his girlfriend's got her throat slit. Knows there are police sitting outside of his hospital room sort of 24/7. I understand they're telling him he's free to leave, but he obviously knows he can't go anywhere. So I'm just curious about the custody analysis. That seems a little more difficult than some of these other issues.
Well, the defendant has, I think, conveyed that he understands that he may be considered a suspect, and he is aware that police were there, which goes again to he's not confused. He knows his situation, but the police have not conveyed to him that they consider a suspect. And
well,
what you would
when
also,
the police sit outside your hospital room nonstop, right? He's aware that there are police officers constantly there, right?
I would say that he's conveyed that he knows that.
Yeah.
That he does know that.
And he knows why they're there, because he's explained that he knows his girlfriend's on the ground. He's found her with her throat slit.
Yeah, well, he has information because of what he did. So, but they haven't. What they say to
we
him,
also know he's conveyed that information that he's. Right.
He said, what are the police here? Why is the police officer here? And he says,
he's also asked the nurse if his girlfriend's still alive, right?
Yes, Yeah, so he's aware of his situation, which I think also goes to voluntariness of his statements. But he's
I'm not worried about the voluntariness so much as the custody analysis.
right.
Mhm.
So when the police are there, they don't engage in any conversation with him until he has this conversation with Trooper McMillan. McMillan says, he comes back and gives him a card. He says, I'll see what I can do. I don't know if I can do anything. And then Trooper Riley is the lead officer, and he goes to the defendant, and the defendant says, he says, how are you? And he says, I can't
Just
talk
follow
right
up on Justice Kafker's question. I mean, if I'm in a hospital room incapacitated and there's police outside the door 24/7, the door is open albeit, but I can't move because I'm incapacitated, but the police are there 24/7, I think I might feel that I'm not free to leave. Why else are the police there?
Well, I think the question is whether he was free to terminate the questioning of with the police. So he is confined by his own circumstances, by his medical circumstances.
Well, in the
but
presence of the police outside the door, right?
and he has the ability to tell them, and in fact, ultimately does tell them he doesn't want to talk to them anymore. That's how that conversation ends. That doesn't come in a trial, but he ends the conversation. And when Trooper Riley first meets him, he says, this is Trooper Darling, we're going to dinner. If you want to talk to him, you could talk to him or let him know. And that's when the defendant says, I can't talk, one more day until I can talk. So the Commonwealth submits that. I mean, that's telling about his medical situation. It's not, it's conveying a fact of what his medical situation is, not that he doesn't want to speak with him.
So are you saying that in the context of being at a hospital, what free to leave does not mean you're intubated and you're in the ICU? Free to leave doesn't mean, okay, I can walk out the front door of the hospital. Free to leave in that context means I am free to leave the circumstances that allow the police to be able to interrogate me.
Correct. And that's just his circumstances. The police did not construct the circumstances that the defendant faced. Yes, they were there, but they conveyed to him several times that he could ask them to leave.
Right, because as Justice Kafker alluded to, we all understand he's not free to call a cab and leave the hospital. But the question is, when we look at the non-exclusive Bryan factors, whether free to leave in this context means free to leave the circumstances that would allow interrogation.
Correct. And I think that's also buttressed by the fact that the tone of the interview is cordial. And also the hospital room itself, people are, it's a bustling place. It's not like he's been, they didn't take him to another room. I mean, they could have done that, I suppose, but they haven't done that. It's still a bustling place. It's not a private place where, where you often think of, where you often know that interrogation would take place with four walls closing in the police with the defendant. That was not the case in this situation.
Are you aware of any cases that deal with HIPAA and how that interacts with somebody's reasonable expectations of privacy in a hospital?
Well, I think under HIPAA, Your Honor, the medical information, a patient can expect that his medical information is between a medical personnel and the patient is private. In terms of most of the information that he conveyed was not medical information. There might have been a little bit about, was he coughing or something like that, but most of the communications that he made were, is my girlfriend okay? Can I talk? What is a police officer doing? They were not, it was not health information.
Well, by the way, is there an express exception on HIPAA for criminal stuff? Does it include an express exception?
There's no, you wrote in your brief, it's never been found to be grounds for suppression, right? There's no private right of action.
There are no grounds for suppression. And the two cases cited by Judge Kinder, the senior case, there's this case out of the Ninth Circuit. And
because there is medical information. Because there is medical information communicated. I mean, they give they tell the police the results of his, the kind of competency questioning they're asking. How delusional is he, right? They give the police, so there is some communication of medical information. It may not be covered by HIPAA, but there is some communication there, right?
I would submit in terms of the cases have been pretty unanimous, and I would say to the case cited by Judge Kidner, which is United States versus Strike, which is a Ninth Circuit case, 560 F3rd, where they found that there's no exclusionary provision for violation of HIPAA, and also Senior, which says a breach of patient-doctor confidentiality would not result in suppression. Here, the notes that were, again, the notes that were taken by Nurse Wallace and given to police were, it was not a serious matter. They were mostly cumulative and did not, they were not inculpatory, but they did set the scene for the defendant's situation. So I would not say if there were a case, and there may be some time where there could be an exclusion based on HIPAA, that this would not be the case at all. The case cited by my brother having to do with, well, when you have a statutory violation, you could have exclusion. Those had to do with Chapter 276, Section 1 violations and would be not applicable on the HIPAA issue. And I would say that the cases nationally, I've not seen where a HIPAA violation would result in exclusion. With respect to the prior bad act, I did just want to correct, there was the prior bad act of the OUI, and the judge gave a final instruction on how to use prior bad acts, and also did give one contemporaneous. With respect to this altercation that had occurred at work, there was testimony about that altercation, and there was a contemporaneous instruction then, but the judge later struck that testimony because it didn't quite match up, and it really kind of put the defendant in a good light. He was, as to what had happened at work, there was no testimony that he had been an aggressor at work. It looked more like he was trying to be the peacemaker. So, but there was an instruction on the OUI contemporaneously and in the final instruction. With regard to text messaging, the standard is preponderance of the evidence to show, that's a standard for finding authentication. And here, the Commonwealth would submit there was extremely strong evidence of authentication, starting with the password protected nature of the phones. And so that would make it more in the Purdy line, where you have a computer with a hard drive, password protected. Here you have the phone, and there was testimony about how that the passwords had to be broken with technology to be able to get into the phone. And then the text messages just so convey the close relationship between the defendant and the victim, the everyday relationship, and all of these conversations that they have with one another. So I think a fact finder and the judge's gatekeeper would be left with feeling very strong evidence that there was authentication of these
Did the text messages reference the OUI or the verbal or somewhat physical disagreement at Amy's place?
They did, Your Honor, because a lot of, and there was only a limited amount of text messages came in, only going back to about February 10th, and the murder happened in the early morning hours of February 20th. But a lot of what was going on the 15th of February, after the defendant's OUI, was her arranging to pick him up from court because he has no car and he has no money to get his car out of storage. And so there were text messages about that. And then before that, the defendant is very tense and very aggravated with the victim because of the situation at work where he was let go at work due to disagreements at work, and she in fact still works there. So he is extremely mad about people at work, and then that frustration flows over to her. And so it really—
Did the jury learn, even though a small percentage of text messages were put in, did they learn about the volume of text messages between the two?
There was testimony that the defendant had 7,600 text messages in his phone, and about 6,900, I think, were between him and the victim. So But again, only 10 days worth were introduced into evidence. There are no further questions. Nope.
All set? Thank you so much, counsel.